In October 1991, with the unfolding of the Thomas Hill hearings, the term sexual harassment took a giant leap into the awareness of the American workplace. Up until then, the behavior we now know as sexual harassment was largely unchallenged and accepted as a fact of life when men and women work together. Fact is, those days are over. Today, the issues and consequences surrounding sexual harassment are forcing businesses and institutions across the country to wake up to this very real problem. In this program, we'll discuss the escalating consequences of sexual harassment and the key steps that you as a manager should take if it happens in your department to protect your employees, yourself, and your company. The first step is knowing exactly what this term, sexual harassment, means.
The legal definition of sexual harassment is unwelcome sexual advances, verbal or physical conduct of a sexual nature, or requests for sexual favors, when those are made a term and condition of employment, or when a decision regarding employment is dependent upon the victim's answers, or when it creates a hostile working environment.
Where there is some kind of conduct that is unwelcome or offensive to the person, that it's directed at that person because of their sex, that it is so severe or pervasive in the environment that it actually changes the terms or conditions of their employment, and that the employer should be held liable for that conduct, and that last standard will change depending on who the alleged harasser is.
Whether a business is large or small, the financial consequences of sexual harassment can be very severe. In almost every case, the complainant and the complainant's attorney are going to go for the deepest pockets, the employer. And the costs incurred aren't limited to settlements when a company is found liable. Almost as soon as a sexual harassment charge is brought forward, a company begins to pay. It may begin with the administrative costs of an EEOC or other agency complaint investigation. There will be corporate attorney fees at the first hint of a harassment defense. Regardless of the outcome, court fees are exorbitant. And with the passage of the Civil Rights Act, federal courts, as well as some state courts, can assess damages of up to $300,000 against the employer. Depending upon the state, settlements can run into the millions.
In addressing the issue of sexual harassment, it's important that a company understand both the federal laws that apply to that company as well as the state laws, because the company may find that the state laws are more stringent, and it's important that they're meeting those state laws.
Awards or judgments in sexual harassment cases can be extremely high. There's a case out of California, for example, in which the employer was exposed to a total judgment of over $3 million. $1.5 million of that was what was referred to as compensatory damages. They awarded both back pay to the individual, front pay, that is money for years that she's not even going to be working at the company, emotional distress damages of over $600,000. On top of that, some states, and in this case California, do allow punitive damages. That is, a jury was allowed to decide we're going to punish the employer for this conduct. And also then the individual company was exposed to paying attorney's fees. All of that came to over $3 million because the company did not act in a timely fashion.
Sexual harassment has cost industries millions of dollars in court and settlement fees. Harassers are paying in lost jobs and personal liabilities. Companies are paying in monetary losses, bad publicity, and lost productivity. As you can see, the price tag attached to sexual harassment is staggering. Step one in avoiding all these costs is to recognize sexual harassment when it occurs, and it usually occurs in 3 ways.
Scott, I think we need to take out a line here.
Move it over. What do you think, Scott, huh? I'm just trying to imagine a golden tan on these beautiful shoulders.
Rick, I don't appreciate that.
Hey,
Come
I'm
on.
sorry, okay? Whoa, Michelle, I'll save it for the beach. Anyway.
Federal law and the law of many states will hold the employer liable for conduct or sexual harassment by its employees if they knew or should have known of the conduct and failed to do anything to stop it.
Oh, the joy of working with a housewife turned career woman. Did you case this? Why don't we try doing it right this time, okay?
If a supervisor harasses a coworker in the company's almost always liable for that supervisor's behavior. This is because the supervisor is viewed as an agent of the organization. The supervisor has been put in a position of authority and power and is often using that authority and power in order to harass the subordinate. So the company's almost always liable. There are two other individuals that may also be liable. The first is a harasser. The harasser can be liable for his or her own conduct. The manager or else a human resource person that knew about the harassment or had reason to know about the harassment may also be liable if they failed to take corrective action.
Paul, you joke around too much.
And I'm serious. No strings attached. Just stay here tonight. I want to show you my appreciation for all the great work you've done on this conference, and we can work on your personal evaluation.
I don't know.
Quid pro quo harassment, it's just sort of a fancy term, Latin term for this, for that. You are, or a person is offered some kind of sexual proposition in exchange for some change in their employment, or perhaps even just keeping their employment.
If it's quid pro quo harassment, the company is always liable in that particular circumstance. And that is because it is generally a supervisor or a manager who is demanding sexual favors in exchange for a job benefit. The company has put that manager or supervisor in that very position to grant or deny job benefits, so the company is liable for his or her behavior.
Often, the form of harassment that companies are most likely to turn their backs on is third-party harassment.
Hi, Danielle.
Hi.
We have a meeting with Ed.
Okay.
Hey, Danielle, how come we never get to see you in your modeling costume when you're up here in the office? I mean, that is you in the poster there, isn't it? It looks just like you.
Is Ed in?
I'll check.
A company can be guilty or found liable for third-party harassment if the company were in a position to know, actually did know, or should have known that the sexual harassment was occurring. I recently handled a case, for example, where a client of the company told an employee that if she wouldn't spend the weekend with him, he would withdraw his business from the firm. She reported it, and the company took no immediate and effective action, and we sued and settled that case for somewhere in the mid-six figures.
As a manager, your company could hold you personally responsible for not dealing with a sexual harassment problem before it became very costly and damaging to the reputation, morale, and productivity of the company. So what do you do if it happens in your department? The particular step that each company may follow will vary, but overall they fall into four categories: investigate, evaluate, take action, and follow up. First, investigate. The most important thing to keep in mind about the investigation is that it should happen immediately.
When a complaint comes forward of sexual harassment, the best thing that a company can do is promptly investigate and then promptly take action based on the results of that investigation. A company has a very good chance of presenting a good defense to any lawsuit if it can say that it took action to end that harassment as soon as it found out about it.
Depending upon the situation of your company, you may want to bring in an outside investigator. Now, you can find one by referring to your state FEP, or Fair Employment Agency. Every company approaches management differently, but because of the sensitive nature of this problem, it's often a good idea to use a man and woman team to investigate so everyone feels fairly represented. A thorough investigation should include the following elements: a pre-printed complaint form that the person filing the complaint can fill out, an interview with the person filing the complaint, an interview with the alleged harasser, including a signed written statement detailing his or her recollection of the events, and interviews with witnesses who may have seen the harassment or experienced it themselves. Also include interviews with anyone else who may be aware of the harassment, such as close coworkers who the complainant may have confided in. A pre-printed complaint form allows the person filing the complaint to carefully and calmly write down everything they can remember. The questions that it contains are similar to the questions that will be asked during the interview.
You need to ask the complainant for an honest and straightforward account of what has happened. Ask them why they're coming forward with a complaint at this point. And also you need to find out what effect is the harassment having on this person. Is it disruptive to their work? Is it disruptive to life at home? And you also should ask the complainant to tell you the names of other people who might have knowledge of the complaint or have witnessed something and can give you additional information or supporting evidence.
How do you feel you've been harassed? He's constantly touching me. He massages my back. He puts his arms around me. He calls me at home. He talks to people about me at work.
What has your response been?
I've told him to stop touching me. I've told him to stop calling, and he won't listen. He just keeps doing it. He thinks it's a big game or something.
You should ask people for specifics like what happened, where did it happen, when did it happen, what was said, how did you respond to what happened, is there any evidence, were there any other witnesses, were there any people that you told about as soon as it happened, and finally, what would you like in terms of complaint resolution? You don't want to promise that resolution, but that does give you some way of judging what might resolve this employee problem. You should tell the employee that you'll protect confidentiality as much as you possibly can, but that it can't be strict confidentiality because the harasser will have to be confronted. However, you should also let the employee know that you do guarantee freedom from retaliation either by the alleged harasser or anybody else who might find out about the complaint, so that the person does feel that there is safety in this complaint process.
Did she tell you to stop?
With the alleged harasser, you want to be direct and methodical. Go through your interview notes from the complainant step by step. Give them the alleged harasser detail, let them respond to each quote, and say things like, I was told that you said this, do you remember it, what happened? Give them a chance to fully tell their version of the story so that you can assess the complaint fairly. You also want to be clear with the alleged harasser that they must not retaliate in any way against the complainant. And often what you'll hear is, yes, I did do these things, but I didn't mean any harm by it. I wasn't trying to be offensive, didn't have the sense that it was offensive, or they may deny it altogether.
Hey, look, I didn't know it was a federal offense to touch a friend. Man, I mean, it's not like I assaulted her or anything.
If the harasser says that they weren't aware that the behavior was offensive, you should ask them what made them think that the behavior was okay.
For your documentation, it's a good idea to get a signed written statement detailing the alleged harasser's recollection of the events. Also, let him or her know that any type of retaliation will be automatic grounds for dismissal. After you've conducted interviews with the employee who filed the complaint and the alleged harasser, you need to interview any witnesses who may have seen the harassment or experienced it themselves. You also want to interview anyone else who may know about the behavior under investigation, such as a close coworker that the employee might have confided in. After conducting all the interviews, the next step is to evaluate the evidence, and once that decision has been reached, take action immediately.
If you can't support the claim of harassment, it's important to let both the complainant and the alleged harasser know that as soon as possible, and then to follow up with some general education on the topic for the work group, because it's going to be in the air and you want people to know that the company does take it seriously, doesn't want it to happen in the future. You may also find yourself dealing with an alleged harasser who's quite angry and who feels falsely accused, and you have to let them know that the company was obligated to take the complaint seriously, to do an investigation, and then perhaps to steer them toward whatever support services you have available. So if, for instance, you have an employee assistance program, it's good to refer the alleged harasser there for some emotional support.
If after an investigation the company concludes that harassment has occurred, the company should take immediate corrective action. What the courts are telling us is that the company should take the action that is reasonably anticipated to stop the behavior. What that action is going to depend on what the behavior was. The more serious the behavior, the more serious the disciplinary action. If it's a situation where a coworker didn't understand that he or she was offending another coworker, no one had ever brought it to their attention, a simple counseling might do the trick. If it's a situation where a coworker continued to make sexual comments to another coworker after he or she had been told it was unwelcome, that's a situation where more severe disciplinary action is appropriate, and it may even be termination in those circumstances.
The final step in the process is to develop a follow-up plan to monitor the behavior. It's a good idea to have follow-up meetings at 2 weeks, 1 month, 3 months, 6 months, and yearly with the employee who filed the complaint to ensure that the harassment has been eliminated and that there has been no retaliation. We've covered the steps that you need to take when someone within your department comes to you with a complaint of sexual harassment. Now let's take a look at what you should do when the alleged harasser is a customer or a client. Now, as you heard earlier, this is known as third-party harassment, and your company is still legally liable for it. This means that it's your responsibility to talk honestly with your client. For example, let's say that 2 of the women in your office told you that one of your most valuable clients had been making sexual advances and pressuring them to spend time with him to keep what he called good customer relations going between the 2 companies. Here's what you might want to say to him.
Jerry, this is a difficult subject for me to bring up, but legally I have to. I've gotten some complaints from my female staff that you've approached some of them with comments of a sexual nature, and that you've asked to spend time with some of them socially.
Well,
I don't want to offend you or anything, but it's a part of what we value in our business relationship. But I also have to be an advocate to my employees and protect this company from any sexual harassment charges.
I understand that.
We take the sexual harassment issues very seriously in this company. And because of that, if any of our employees were to press charges because of one of our clients' behavior, well, we're legally liable. So I need to ask you to stop any behavior that is not of a strictly business nature.
It's important to remember to talk to your managers before you take this step so you can say you're speaking with their support. Upper management support is essential to making a company-wide commitment to prevent sexual harassment. The best prevention is to have a strong sexual harassment policy that clearly states what sexual harassment is and the consequences if it happens.
To have a good, effective sexual harassment policy to which management is thoroughly committed, to inform people as to what it provides and provide training regarding its provisions.
They are not something that's going to go away right away. They are here to stay. There is enough evidence to suggest that claims will continue to be brought forward and that costs will continue to escalate, not go down. They will continue to go up for sexual harassment claims. So the exposure is going to be greater and greater, and therefore the incentive for the employer to take action before it gets to the stage of a lawsuit is even greater.
No matter what your policy is, here are some reminders for those areas that may seem a little gray.
If coworkers have had a romantic relationship and that relationship has ended, and now one of the coworkers is sexually harassing the other in the work environment, the manager should take immediate corrective action if he or she is aware of it. It's a situation where it's no longer a personal issue, it is now a company issue because you have an employee in the work environment who is uncomfortable and being subjected to sexually offensive behavior.
The employer also may have a responsibility and liability if the harassment is done by a customer or a client or a third party, somebody who's not one of your employees.
The sexual harassment standards for physical harassment or stories, jokes, innuendo, that kind of thing, are exactly the same if it's a company-sponsored off-site party or event as they would be if the behavior took place in the office. If it's a non-sponsored event, but the behavior then has repercussions in the office, the company would also have a responsibility to deal with those repercussions.
This program is clearly not the final answer to sexual harassment in the workplace.